In this video, we will be looking at a case of Mayfair Ventures Sdn Bhd and Setiakon Builders Sdn Bhd, which is a recent decision of the Court of Appeal on a construction claim under the adjudication regime of CIPAA. For the uninitiated, the Construction Industry Payment and Adjudication Act 2012, or CIPAA in short, is a legislation that was passed by Parliament to address various shortcomings faced by the parties in the construction industry. Back then, if there was a dispute between, say, a contractor and an employer, they would have to resolve their differences in court of law or arbitration if there was a consensus between parties to refer to the latter. Arbitration processes were known to take years before an award is published. And unlike today, wherein various states have specialized construction court, back then as well, specialized construction court has not been established, meaning that parties would file their redress to court. They would end up in a civil or commercial division of the court like any other claims. And despite reforms and modernization by Tun Zaki, the former Chief Justice, to speed up the judicial process, the fact remains that every day counts when it comes to getting payment for a contractor. Not getting paid means not being able to pay their subcontractors and workers. That would then lead to contractors themselves defaulting against their subcontractors who may refuse to carry on works, and that will have a domino effect on timely completion of whatever project that is, which will lead to liquidated damages against the developers. It is no wonder every lawyer arguing for speedy payments on behalf of their contractor clients will often quote Lord Denning's famous statement, "Cash flow is the lifeblood of the building industry," in the case of Donways Limited and FG Minter. Across the globe, other countries have begun establishing mechanisms known as adjudication as alternative dispute resolution in order to address the cash flow quandary. It is often cited as a pay first, argue later stopgap, where the decision would be fast and have a temporary finality. The United Kingdom introduced statutory adjudication for its construction industry on May 1998, with the coming into force of the Housing Grants Construction and Regeneration Act 1996. In Wales, adjudication came into force in New South Wales on March 2000. The state of Victoria followed suit in 2002, Queensland and Tasmania in 2004. Singapore, across the causeway, joined the bandwagon in April 2005 with the implementation of the Building and Construction Industry Security of Payment Act 2004. And Malaysia finally implemented its own adjudication in 2014, and this is where CIPAA comes in. The long title of the Act expressly states that this is an act to, quote, facilitate regular and timely payment, to provide a mechanism for speedy dispute resolution through adjudication, to provide remedies for the recovery of payment in the construction industry, and to provide for connected and incidental matters. One of the ways CIPAA achieves this aim is by the introduction of statutory adjudication to the construction industry. Like many acts, CIPAA has its own fair shares of challenges. Through the years, the courts have interpreted its applications and limits. For instance, in Renhill EC Sdn Bhd and Teosite Sdn Bhd, which the High Court held that CIPAA, being statutory adjudication, cannot be opted out or contracted out of. The Federal Court in View Esteem Sdn Bhd and Benapuri Holdings Bhd held that the failure to respond to a payment claim does not prevent a non-paying party to raise a defense later in its adjudication response. The Court of Appeal in Likas Bay Precinct Sdn Bhd and Benapuri Sdn Bhd, which held that a successful litigant in a adjudication proceeding need not have to register or enforce the decision under Section 28 prior to the issuance of a statutory notice under Section 465 of the Companies Act 2016 for the purposes of instituting a winding up. Then there is the Federal Court decision of IRECA Engineering and Construction Sdn Bhd against PwC Corporation Sdn Bhd, which held that adjudication does not apply to contracts entered into prior to the coming of force of CIPAA. I remember clearly how many adjudication decisions were set aside during this period, which included one which I was involved in. Then there is a case of JDI Buildtech and Danga Jet Development, in which the Court of Appeal held that the prohibition to conditional payment under Section 35 of CIPAA is confined only to adjudication proceedings. And shortly after, the case of SPM Energy Sdn Bhd and another against Multi-Discovery Sdn Bhd, also a Court of Appeal decision, deciding the other way around, that pay when paid is not confined only to adjudication. That itself deserves a conversation in a separate video for another day. But for today, the video is on another Court of Appeal decision on a separate topic. Mayfair Ventures Sdn Bhd and Setiakon Builders Sdn Bhd. The facts of Mayfair Ventures are as follows. Setiakon Builders was appointed as the main contractor by Mayfair Ventures for the Lumi Tropicana project. The contract adopted a PAM, Standard Form Conditions of Contract 2006, which contains a standard clause that allows for late payment of interest. Clause 30.17 of PAM contract states that for payments made after the period of honouring certificate, a simple interest based on the Maybank BLR plus 1% shall be payable by the defaulting party on such outstanding amount until the date of payment is made. Anyways, works was completed, project was handed over, and defects liability had expired. However, dispute arose between the parties as to payment. Setiakon commenced adjudication claiming for payment under 3 headings. The first was for unpaid balance under 2 certificates being 44R and 46. The second was for the release of retention sum. And finally, at the heart of the controversy, a claim purely for late payment interest. Now, the interest due to late payment is presumably from payment certificates other than the certificates under Certificate 44R and 46. It was not disputed that those principal amounts have been paid by Mayfair, albeit late, which led to the accrual of those interests. The adjudication issued its decision. It did not allow Setiakon's claim for release of the retention sum. However, she allowed Setiakon's claim for the unpaid balance under the payment certificate 44R and 46, and she also allowed a substantial part of the late payment interest. Now, dissatisfied, Mayfair Ventures applied to set aside the said decision. Mayfair's contention on the late payment interest was basically that the adjudicator did not have jurisdiction under CIPAA to decide and order late payment interest where the principle under which the interest accrued had already been satisfied before the payment claim was issued. The High Court disagreed with Mayfair, and this is what her ladyship said. Mayfair did not deny on the accrual of the late payment interest, but only that Setiakon is not entitled to claim for the same via the adjudication proceedings, since the principal amount had been paid by Mayfair for PCs numbers 1 to 46, for which the adjudicator has no jurisdiction. As stated by Setiakon in its payment claim pursuant to clause 30.17 of the COC, Setiakon is entitled to a simple interest based on Maybank base lending rate plus 1% payable by Mayfair on default of making payments within the given due date to making payments. Since there is no denial of delay in making the certified payments to Setiakon, and resulting from that delay, interest had accrued by virtue of the COC and had become payable, it is my view that the late payment interest claimed by Setiakon is payment as defined under the CIPAA 2012. Paying only the principal amount and not the accrued interest would tend to amount to a non-payment for work done or services rendered under the construction contract by Mayfair. The fact remains that Setiakon had made its claim for late payment interest in its payment claim, and undisputedly, Mayfair neither denied the claim nor raised any jurisdictional objection to Setiakon's claim in its payment response or its adjudication response. However, when Mayfair appealed to the Court of Appeal, the appeal was allowed and part of the adjudicator's decision ordering late payment interest was set aside. There are 2 grounds as to why the Court of Appeal decides so. The first is an interpretation of jurisdiction. As a starting point, the Court of Appeal considers Section 27 of CIPAA, which provides what is the scope of an adjudicator's jurisdiction. Section 27(1) of CIPAA states, subject to subsection 2, the adjudicator's jurisdiction in relation to any dispute is limited to the matter referred to adjudication by the parties pursuant to sections 5 and 6. Sections 5 and 6 refers to the processes of raising disputes under CIPAA. Section 5 sub 1 says that an unpaid party may serve a payment claim to a non-paying party for payment pursuant to a construction contract. Section 5 subsection 2 provides that a payment claim must be in writing and what it must include to constitute a payment claim under the Act. Section 6 deals on how the non-paying party may respond to a payment claim. Anyway, let's circle back to Section 5.1 because this is important. You see, Section 5.1 says that payment claim is for quote-unquote payment pursuant to a construction contract. Section 4 of CIPAA 2012 defines what payment is. It says payment means payment for work done or services rendered under the express terms of a construction contract. It is on that premise that the Court of Appeal held that interest alone does not fall within the definition for work done. If the dispute is not a dispute of payment as defined in Section 4 of CIPAA, then the same falls outside the core jurisdiction of the adjudicator. In this regard, the Federal Court in Martago Sdn Bhd and Architect Myo and Chiu, Federal Court Justice Sawawi Saleh, held as follows. A broader view in understanding Section 5 of CIPAA 2012 is supported by Dr. Professor Sundaraju in A Practical Guide to Statutory Adjudication in Malaysia, which was published by KRCA, wherein the learned author said, under CIPAA, the unpaid party is only allowed to refer a payment dispute to adjudication. Section 4 defines payment to mean payment for work done or services rendered under the express terms of a construction contract. As such, the definition excludes references of extra contractual claims such as tortious claims or general damages arising from breaches of contract. In Rocha Dynamics Sdn Bhd and Muhammad Saliuddin bin Sabai, Justice Wong Ken Keong, as he was formerly known, held as follows. It is clear from the definition of payment in Section 4 of CIPAA that an unpaid party can only claim for work done or services rendered under the express terms of construction contract. Hence, an unpaid party cannot claim under CIPAA for any loss of profit due to a breach of construction contract. Section 5 sub 2 sub C CIPAA provides that a payment claim shall include a description of the work or services to which the payment relates. Such a mandatory requirement of a payment claim in Section 5(2)(c) CIPAA fortifies the fact that an adjudicator's jurisdiction under CIPAA is confined to a claim for payment for work done or services rendered under a construction contract. It is clear from the long title that Parliament has intended for CIPAA to provide an expeditious recovery for payment for work done or services rendered under the express terms of construction contract. And 5, if any party in a construction agreement X has suffered any loss of profit due to a breach of the agreement X, may recover such a loss in civil suit or arbitration if there is an arbitration agreement. Well, if so, then how does the Court of Appeal reconcile the power to order interest when it has no jurisdiction to decide on a claim purely on late payment interest? Well, the Court of Appeal distinguishes the terms jurisdiction and power. It held the term jurisdiction and power of the court has been explained in the case of Lee Cheng against Xiao Peng Huang by C.J. Thompson in the Federation of Malaya's Court of Appeal case as follows. It is axiomatic that when different words are used in a statute, they refer to different things, and it is particularly so where the different words are, as here, used repeatedly. This leads to the view that in the Court's Ordinance 1948, there is a distinction between jurisdiction of a court and its powers, and this suggests that the word jurisdiction is used to denote types of subject matter which the court may deal and in relation to which it may exercise its powers. It cannot exercise its powers in matters of which, by reasons of their nature or by reasons of extraterritoriality, it has no jurisdiction. On the other hand, in dealing with matters over which it has jurisdiction, it cannot exceed its powers. The significance of divide between jurisdiction and powers lies in the fact that jurisdiction relates to the types of subject matter which the court may deal with, whereas its powers may be exercised only in relation to the jurisdiction. As we have explored above, Section 27 of CIPAA determines the adjudicator's jurisdiction, which, as we have seen, is limited to the matters referred to adjudication pursuant to Sections 5 and 6 of CIPAA. However, in contrast to Section 27, the powers of an adjudicator is listed in Sections 25 and 26 of CIPAA under the specific heading of powers of adjudicator. It follows that an adjudicator may exercise all or any of the powers under Sections 25 and 26 of CIPAA so long as he keeps within his jurisdiction in adjudicating only the subject matter referred to him pursuant to Sections 5 and 6 of CIPAA 2012. The court pointed out that Mayfair Ventures' case herein have nothing to do with the power of the adjudicator to award interest and costs under Section 25(o) of CIPAA. It says the power of the adjudicator under the 6th section to award interest is a consequential power tied to an unpaid amount for work done. It does not extend to adjudicating claims solely for interest or financial losses not related to work done. There is a second ground for allowing the appeal, and it is this. You can see here at paragraph 57 of the judgment, the first part of the paragraph is the first ground as we have covered. The second part starts where the court says, learned High Court judge has not a fact that before the payment claim, Setiakon did not claim the said late payment interest from Mayfair. Thus, Setiakon's claim for late payment interest in the payment claim is not, quote, the amount claimed as provided in Sections 5(2)(a) of CIPAA 2012. The amount claimed must include any part of the amount already claimed by the claimant or unpaid party from the non-paying party before the payment claim is served on the non-paying party, which unfortunately is absent in our present case. The court's ratio here is based on its earlier decision in Puncak Niaga Construction Sdn Bhd and Mersing Construction Engineering Sdn Bhd. I will discuss this case later on in this video. But for now, this court in Mayfair held, apparently relying on Puncak Niaga, since the amount for the late payment interest was never claimed before the payment claim was served on Mayfair, Setiakon cannot be considered an unpaid party under Section 4 of CIPAA. Consequently, Mayfair is not a non-paying party and payment claim is invalid and improperly served on Mayfair. What do I think about the decision? Is it correct? Well, it's not for me to question the wisdom of the Court of Appeal. Personally, the first part of the ratio is sound as to how a standalone claim for interest is not within the definition of payment for work done if we read strictly into Section 4 of the Act. However, the ratio may have repercussions on other types of claim, normally brought up in construction contracts. For instance, loss and expense in association with prolonged construction period. Will they also be interpreted similarly? Well, in Integral Acres Sdn Bhd and BCEG International Sdn Bhd, the issue was whether the adjudicator had jurisdiction to decide on loss and expense that was incurred by a contractor during the period of extension of time. Adopting a very similar approach, Justice Wong Kee Keong, as he was formerly known, held that an adjudicator had no jurisdiction to decide on loss and expense under an extension of time as it was not works related. That was a High Court decision. Now, diametrically in opposition to Integral Acres are cases such as SKS Pavilion and Tasun Injection Pulse Sdn Bhd, Syarikat Bina Darul Aman Berhad and Government of Malaysia, and the case of Pintaras Geotechnics Sdn Bhd and KKH Development, which all held that loss and expense claims are within the definition of Section 4 of CIPAA. Now, these are all High Court cases, so it would be interesting to see if the ratio in Mayfair Ventures would have a different outcome on the question of whether loss and expense falling within the ambit of adjudication under CIPAA or otherwise. The second ground of the Court of Appeal, i.e. Setiakon's claim for late payment interest failed because Setiakon had never claimed for this prior to issuance of its payments claim. Now, I'm going to be honest, I have two observations to make about this ratio. Now, firstly, as discussed above, the court relied on its earlier decision of Puncak Niaga. In that case, Mersing entered into a subcontract with Puncak Niaga for laying of sewage pipes. Having carried out the work, Mersing issued its interim claims to Puncak Niaga for certification and payment. Those interim claims had neither been certified nor paid. Eventually, Mersing discovered that some of those claims had errors in it. However, instead of submitting those claims to Puncak Niaga pursuant to contractual provisions, Mersing issued a payment claim under CIPAA for non-payment. Now, Puncak Niaga argued that Mersing's revised claim was premature and therefore not due as they had not been submitted for Puncak Niaga's certification. And as such, Mersing was not an unpaid party under Section 4 of the Act. The Court of Appeal held that Mersing's revised claim was not outside the purview of Section 4 of the Act and that the adjudicator had jurisdiction to decide on his claim. Now, this is what Justice Nadabharan held. The question here is whether the adjudicator exceeded his jurisdiction for having adjudicated on Mersing's payment claim, which included rectified claims. At the outset, we may state that it is our finding that the payment claim that was submitted by Mersing is not premature and comes within Section 5.2 CIPAA as it is in respect of claims which are due under a construction contract. As such, the adjudicator has the requisite jurisdiction to deal with and determine the claim on its merits. The rectified claims were part of the payment claim and they are therefore within the jurisdiction of the adjudicator. Next, the court held that Mersing's claim was not a new claim, but rather a refinement of its earlier claim. It is quite obvious that the rectified claims relates to work done, for which claims had previously been made to Puncak Niaga, which were not certified. Thus, when the rectified claim was made as part of the payment claim, they were not new claims, but a scaled-down version of an earlier claim which contained erroneous figures. Puncak Niaga's objection is that the impugned items consisted of claims amount which Mersing had unilaterally rectified without any prior reference to Puncak Niaga. The rectification of the amount was due to errors in the amounts previously claimed by Mersing in the monthly claims. This value of the 5 items is about 93,507 cents. In our view, the rectified claims were merely a refinement of the previously submitted monthly claims. Thus, it is not a new claim, but merely a refinement of a claim which had been previously submitted to the employer. Therefore, it is valid for the purposes of adjudication proceedings. We agree that a payment claim which consists of a premature claim or an in futuro claim is not one which complies with Section 4 and 5 of CIPAA. But that is not the case here. The fact that Mersing did not resubmit the rectified claims through a route of Clause 8.1 of the LOA is not an impediment to the impugned items being submitted as part of the payment claim, because the claims are in fact for work done under a construction contract, and the claims had been submitted previously to Puncak Niaga. And all that has happened is that these same claims have been refined or pruned by way of discarding erroneous amounts before being submitted as a payment claim. So in Puncak Niaga, Mersing's claim, despite being a revised claim, was allowed, notwithstanding this revised version was never submitted prior to its payment claim. Of course, in that case, Mersing's claim were not new claims, but rather a revision or a refinement of its older claim as held by court. Now, as for my first observation, that payment claim will be premature if it contains a claim for work wherein the unpaid party has not carried out the obligations under the contract to submit their claims to the non-paying party, but instead proceeds to claim via a payment claim. However, the second observation is this. The court in Mayfair Ventures must have likely viewed that the claim for late payment interest must be premature, since it was not submitted to Mayfair prior to the payment claim. But this is the interesting point, because Clause 30.17 of PAM, which allows for late payment interest, it actually does not prescribe a claim or submission mechanism. Now let's have a look at it. If the employer fails to pay the contractor the amount due on any certificate, less any liquidated damages and set-off which the employer is expressly entitled to make under the contract after the period of honouring certificates, or the contractor owes a debt or fails to pay any sum due and owing to the employer within 21 days after receipt of a written notification by the employer of such debt or amount owing, a simple interest based on the Maybank base lending rate plus 1% shall be payable by the defaulting party on such outstanding amount until the date of payment is made. So in that case, how can it be said to be premature on the basis that Setiakon had not submitted a claim for late payment interest prior to the payment claim, when the contract itself does not say you need to do so? So yeah, Mayfair Ventures, an interesting development with possibly far-reaching consequences in the adjudication scene. I'd love to hear from other practitioners in this space as to their views. And until then, thank you.